Welcome back to Layman's Law School. I'm Chace Hawk, and along with my co-hosts here today, Reid Sanders and Shawn Merzlak, we're going to be discussing the Second Amendment. We plan these things out a little bit ahead of time, and we try to tie into the issues of the day. And we were covering the Second Amendment because the Supreme Court is hearing a case, or was hearing a case, for the first time in 10 years on the Second Amendment. And they thwarted our attempts to kind of get ahead of it because they came out with that decision yesterday.
Day before us.
That's right, a day before.
I think that our podcast is putting pressure on people. You know, they're trying to beat us to the scoop.
I see. So, yeah, we're going to talk about that decision as well as some of the other Supreme Court decisions that have been used to interpret the Second Amendment and discuss what it kind of means for everyday Americans out there in different states, especially here in Georgia and South Carolina. So the case that or the Second Amendment altogether, people a lot of times don't know that this is one sentence.
Small sentence.
Yeah.
Small sentence, 27 words.
And it goes back to even when Whitney was on, and we've talked about it a bunch. Mm-hmm. Some of the law that it's hard for people to understand. I always give the example of Bill Clinton saying "is." What is the definition? Is. This is a very good example of why every single word matters.
Yep.
Because you're going to have an argument over every single word.
Yeah, so this 27 words produced an opinion that has 157 pages. There are about 87 amicus briefs that are all multiple, 30, 40, 100 pages long, all trying to interpret what these 27 words mean. So this
just some levity to how many pages that how many pages have been written, legal pages, not newspapers or things like that. Mm-hmm. How many pages have been written that you think deal with this issue for these 27? Millions?
Thousands. And Chace has read every one of the amicus briefs, so he's fully
prepared. He memorized
and
them.
he did the entire 160 page opinion overnight.
Good.
So that he can explain all of this to us and what it means.
I am a speed reader. I can do all this. I do have a photographic memory. It doesn't mean I'm better than you, Shawn. It just means I'm different, okay? But before we do that, before we really get into it, it is Friday. We have a tradition. We celebrate getting through another week.
Successful week. Good week.
Good week.
Hawk Law Group.
That's right. And Reid, what do you have for us here, sir?
Surprise? I was not really.
Mm-hmm.
I fell down. I had some kid issues at the house. I wasn't able to go get the special brand. Mm-hmm. So this is just your run-of-the-mill
2022
right. Bud Light. Right. I didn't even get the black bag.
That's right. Well, it's a new year. It's 22. These are the law in 2022.
That's true. Okay. So cheers.
Yeah.
Cheers. It's got the best hops and the best barley around.
It doesn't hold. You got to hold the flavor for a couple of years to really. I know how Chace loves.
I'm acquiring a taste for this.
Yeah,
it's like lake
water. It's
like
a lake water.
I was thinking it's like the hot dog of beers.
Absolutely.
You know what I mean?
That would be a great slogan.
Yeah.
It's the hot dog of beers.
Okay, so I brought a little something different today. I brought a bottle of Prosecco and sparkling wine, champagne, however you want to call it. It's what the Italians call their sparkling wine. But we're celebrating a little bit today because I picked up a judgment for one of our clients. We went to a final judgment in order. She went to another lawyer. He said he couldn't do any. I knew it was going to D'Angelo, apologize.
D'Angelo.
Poured all over my electronics, too. Oh. All right. We can keep that in.
Bud Light's never done that.
Oh, yeah. But the other attorney gave her a case back, said he couldn't do anything for her. And today I picked up a judgment for $298,000 for it.
That's fantastic, man. Congratulations.
Thank you. Well, it's not just me. It's
I know, but I know you worked really hard on that, and
Mm-hmm.
I've talked to you about that case and had some very complicated issues. So you did a great job on that.
And number one thing, I'm sure the client is thrilled.
Jumping up and down. D'Angelo, I'm including you in this.
As always.
Thank you.
You're very welcome.
Cheers to you.
Cheers.
Congrats.
Happy Friday, guys.
Goodness.
This camera's catching all kinds of.
Yeah, we got
fantastic.
all kinds of stuff. Lot of editing for D'Angelo today.
So, the Second Amendment, for those that don't know, it states that a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Seems pretty simple.
Seems pretty simple. But one of the things that courts have held on to for a long time is that phrase, well-regulated militia, and what that means and what bearing that has on the actual second part of the actual sentence. And traditionally, it was read as all one thing. There's a lot of cases out there that talk about, back then when this Constitution was written, the militias was all we really had. We didn't have a standing army to defend the nation. And so it was very, very important for able-bodied men to be able to have weapons at their home. It was also important just for basic self-defense. This was a dangerous land. You had attacks by Indians. We were dealing with wild animals. This was a rural area, and in rural areas, you have to be able to defend yourself. You are on the food chain in a lot of areas in this country, Alaska, the Pacific Northwest.
I think that's important to think about too. Everybody nowadays thinks of self-defense as, oh, I'm worried about getting mugged or robbed in the street, or attacked, something like that.
Right.
When you think about the original self-defense, it included people as well as all these other hazards that were out there, wild animals and, Indians that, we were taking their land from them and all sorts of stuff.
Yeah, in a good comparative to, I would say, like living in Alaska or the Pacific Northwest, where you have wolves, where you have bears, that type of thing. I had a friend from South Africa, and it was just well known that they carried large caliber rifles all in their car. Everybody had a pistol just on them because if they're going from town to town and their car breaks down,
lions, tigers, water buffalo,
right? So that was some of the things that were, that came to bear in this particular case that the court just decided. But before we talk about that, we're going to talk about two other important cases, Heller and McDonald. Okay. Sure. Heller was believe it or not, a 2008 case was the first time that the court had really ever ruled on or given any sort of guidance as to whether or not that right to bear arms included the right to have a gun in your home.
Well, and I think that was, there was so long of a period, there was no action in the Supreme Court because, we had an increase of gun laws that were being, regulated throughout various states. And we also had an increase in organizations, nonprofit organizations that supported one side or the other. And you got to think about these cases in the Supreme Court. Somebody's financing these cases to get there.
Yep.
Absolutely.
If Shawn Merzlak, constitutional rights are infringed upon by somebody, and I have a case, I don't have the money to pursue it and appeal it from Georgia to the, Georgia Supreme Court to Court of Appeals, and then get to the Supreme Court. There's no way that I would have the financial resources to do it. So
and on top of that, Shawn, you got the Supreme Court has hundreds or thousands of cases that they could look at.
Sure.
They have to choose which one. So then you start talking about you have to have lobbyists to get it in front of them and all that. So I agree. I mean, there's no way you would, even if you got it in the stack, you still wouldn't get it selected.
Absolutely. And it's different special interest groups that have a will and desire to get clarification on the law, to change the law, that are often championing these cases. And sometimes even picking out the case from the get-go.
Right.
Reid, you don't have a criminal background. You live in this state.
Right.
You're a good person, upstanding character. I want you to go try and do this.
Right.
For the purposes of...
to move it up, because it wouldn't be ripe if you didn't do that. Yeah, that's a lot. That's where you get kicked out of court if your case isn't right. That means you didn't essentially... you gave me an action that I didn't take, and you want to bring it up with the court. The court's going to say, well, that's not right. So I have to take the action to make the court make a decision on it.
Well, what about one thing that I thought would be interesting for laymen? Chace, why can't we just ask the court in advance for some guidance?
Well, there's a specific way in which a case actually comes to the Supreme Court. There's very limited areas of what they have, what they call original jurisdictions, issues between states. issues that involve treaties, I think, between foreign countries and the United States. But there are specific areas of law where there's a course that the case has to follow. So typically you would bring your case in a local trial court or local federal district court, and then that court makes a decision. And depending on how you feel about it, you can appeal to the Court of Appeals, and they can accept or deny your appeal. Usually they'll accept it in most cases, unless the law has very strongly been handed down against your side. And then from that case, if you're decided harshly against again by the Court of Appeals, then you can appeal to the Supreme Court, and the Supreme Court can decide whether or not to actually hear your case or not. And based on whether or not they accept what they call certiorari, by denying certiorari, one of the things they're kind of saying is like, this is decided, and you're not coming before us. Okay.
Correct.
Yeah. And it's a well-decided thing. It's not an issue that needs to be readdressed, or there's not new.
It's not a difference in facts.
There's not a difference in facts, exactly. There's not a difference in the factual issues or the legal issues involved in this case, and so we're not going to hear it. But they only have so much time, and like we explained, there's a 157-page, opinion.
Right.
These are busy folks, and they got to read all these amicus briefs. They got to read,
and it's extremely complicated.
Yep.
Extremely complicated. And I know, Chase, you were going to get into it some, but it's the interpretation. You would say, okay, well then how do you interpret it, right? Well, the interpretation has interpretations, right? So
Sure.
you can look at it as how the words are meant today. You can look at it and try to figure out how those words were meant when it was written.
Right.
And there's arguments between those two. So there's no, the rabbit hole just gets worse and worse and worse as you go on, because truthfully, it was poorly written, in my opinion, because it wasn't clearly written. It's ambiguous in the way it's written.
And they're always going to leave things
Sure.
that are open. Even
Absolutely.
in this opinion that we're talking about today, there's things that they leave.
Well,
I guess
that-
some of these things would be presumably reasonable.
If blah blah blah, yeah,
right.
and that's the hard part to me in this amendment. That's the hard part to me is, are you looking at it as the words were meant back then, like Chase, you're talking about? Well, back then militia meant essentially the military.
Yeah.
And
A
now
group
that's
of
not
locals that defend your area.
right,
Yeah.
and now that's not the case. But so how do you talk about
Parse
that a little
that.
bit? How do you view statutes, amendments, and what are those kind of levels you go through?
Sure, there's a series of different philosophies when it comes to the law and how it's interpreted. There are what they call strict constructionists. These are people that believe whatever is written there, you determine what was meant at the time by it, and that is what it means. For instance, when you're talking about the First Amendment, and it says Congress shall make no laws, prohibiting individuals from limiting their free speech. That means no laws. That means
Right.
that you can go into a crowded theater and, according to a strict constructionist, and yell fire. You can go
Right.
into a courtroom and yell whatever you want, wearing a shirt that says the judge is, a jerk.
Sure.
I wouldn't try that right
Yeah.
now. That would it would be a bad day for you.
Constructionist also would be one that would try to look at the words meaning at the time it was written.
Yeah, they have different names. They have
Right.
there's what's called a textualist, and the textualist actually will look at the words, but also
Right.
look at the context in which it was written. And so it means a certain thing, but also, for instance, what does it mean to bear arms? Okay, well, a textualist would say, what is an arm? Well, they look back to 1791. All right, they see that they're muskets. Does it mean muskets? No, because contextually, what it means is like that is the highest form of military weaponry
Right.
for self-protection, for actually protecting the free state that an individual could own at that time.
Right.
Okay, and so they look
Because
at the
that's all that existed.
existed. Right. We didn't have modern-day handguns, machine guns, that type of thing, and so a textualist would include all those kinds of things in
Right.
it, and a strict constructionist might look at it completely different. Sure. And then you have a more pragmatist, type look at the Constitution. These pragmatists, they bring their reason, they bring their sort of moral compass into effect, and this is where people have a hard time with justices a lot, because it can come across as them feeling like they're being like activists. Okay, but the truth of the matter is, I think, like philosophically and academically, they believe that the Constitution is a living document. That the framers understood that society would change, that social norms would change, that what was being given to them was a framework from which the government and the justices should work, but all geared towards affecting the competent and good management of this country for its prosperity. And so the pragmatists actually look at the way in which they interpret the words and the actual effect that interpretation will have on
versus
society.
another
Exactly. So if they interpret it one way, they got these difficulties. They interpret it that,
The simple explanation of that is saying they look at the purpose of it and how to apply that same purpose
right
in this time.
Right.
Would that be fair to say?
Yeah. Well, to
an extent, I mean, that's a very simplified, version.
Yeah, but
It's the Layman's Law School, Chase. We got
Sure. I got you. But all right. So, but if we brought back a bunch of people from 1791, and we brought them into modern day society, they couldn't hardly function.
No, they would not be able
in
to
this
function.
environment.
It would be cool.
That would be cool.
Yeah.
Bill and Ted showed me that they have some cool dudes back there,
man. They couldn't hardly function.
No, they wouldn't.
Right. And so that's the challenge that these justices have, because they're torn between what their role is and what the limitations of the Constitution says. Like, they are there to interpret the text. They're not there to write laws.
Right.
Okay. But at the same time, they have a deep understanding of what the practical effect of their decisions will be.
And to your point, Chase, these justices are, it may be all three of these. Sometimes there's one of these. Sometimes they're a mixture. Sometimes they're, so these justices are fighting each other, not on necessarily what they believe, but how they believe to interpret things. And like you said, I mean, there's different thoughts on how to do that.
Right.
And that's, you might have one that's a pragmatist and the other one is a contextualist and all that. And so they're fighting on my way's right, not your way.
And you often see that. We see that in this opinion.
Absolutely.
That came out that, why it was, a majority ruled in a particular way. There's two or three at least that wrote their own little opinion on the side saying, I agree totally with what was said, but I have a little bit different reasoning. I think these things should have been brought out, and that's the reason that, I think isn't really important.
And you said a little bit earlier, you led to that earlier, that's where you leave the door open.
Correct.
And the law, the door's always open in the law.
We like the door to be open.
The door's always open. It reminds me of the thing my dad I always tell, things that I've heard over the years from my dad. And he told me, as a DA, he had a case and the facts were against him. And he asked his ADA to look up something on the law. And ADA said, well, it just doesn't, we don't have a good position. And Dad told him, said, well, go find us one. And that's really, if you can simplify the law, that's the truth. There's an argument on both sides, regardless of what your case is. The law allows for you to, if there's no such thing as a slam dunk in the law, in my opinion. There's an argument that can be made on either side, and that's what makes these things like an amendment that's so old and been interpreted so many times in so many ways, and now put into our society, and now we have the job to try to interpret it in a way that is best.
That's right. And I don't know, man. You said there's no slam dunk case, but did you watch the Johnny Depp trial? I'm just
Well, I didn't say it was a good argument. I said there's at least an argument.
There is an argument. Yeah.
So, Shawn, I think it's a good question for you. I mean, you have by far the most experience with guns, being a being a police officer, an investigator, a prosecutor, defense attorney. So you've kind of gone through all the levels. What was your reaction? Did you agree, disagree with the New York State Rifle and Pistol Association versus Bruen? I know I didn't say that correctly, but it's a long name.
I did agree with it, and I thought that based on how the court is composed right now, I expected that to be the decision.
Yeah.
Ever since the Heller decision and the McDonald decision, those have been steadily increasing the rights that have been given to firearms owners, in America. And like you said, they leave something out.
Right.
In the Heller decision, that involved Washington, D.C. That was, Washington, D.C. is not a state. It's a part of our United States, but it's not a state.
Right.
So does that decision affect all the states, or does it just go for Washington, D.C. that is regulated totally by the federal government? And then when you got to McDonald, which was a case in Chicago, which Illinois and Chicago always have had strict gun laws.
Right.
That is really the opinion that said, no, people have a right to bear arms. They have a right to possess handguns. And that's in every state, not just Washington, D.C. That, through the 14th Amendment, we guarantee, that these rights will not be infringed by the states.
Right.
Yeah. And so just to be clear, it's like in Heller, it involved a person that was trying to get a license just to have his gun at home in Washington, D.C., because Washington, D.C. had some really, periods there was some really bad violent crime, and they really cracked down on handguns, and it's a political, hub, and they were trying their best to control some of the violent crime there. But that law went too far, and the Supreme Court said, because it's like that Second Amendment right is super, super strong, is what they have said, based on America's history and tradition. That's what they're basing a lot of these opinions on. What does it mean to the right to bear arms? Okay, in Heller, it said you 100% have the right to bear an arm in your home, and pistols are included. Now, the nature of the actual weapon, that they're still allowing to have some sort of regulation of. You can't necessarily have a grenade launcher in your house without any sort of major, regulation or, like that, because there's a compelling government interest there in actually controlling weapons like that, okay? And like you said, McDonald, what they did was they said, because Heller was District of Columbia versus Heller, that's International City, okay, Washington, D.C., and then McDonald came in where the city of Chicago had banned handguns. Someone actually applied to try and get a handgun in their home and have their handgun. They couldn't, according to the laws of Chicago. They challenged that law, and then in McDonald v. Chicago, the Supreme Court says that applies. This rule about being able to keep your gun at home applies across the board. In this case, in New York, what occurred was New York has what they call a May issue law, and it was basically that,
which I would consider a rare issue law.
Yeah.
I have relatives that are firefighters and police officers, retired police officers in New York on my wife's side.
Yep.
And now that they're retired police officers, just for them to possess a weapon, they have to have like 3 or 4 different licenses.
Right.
Well,
3 or 4, and they're former police officers. In Georgia, it's kind of like, oh, you're a retired police officer.
Yeah,
you get slap on the back, you're good to go.
To me, it's this. I agree with you on that. I didn't have any doubt in my mind that this was going to be the decision. I had no doubt at all. And the reason that I didn't is because the way that New York had their law, right, and it was not a small step. It was a giant step. Well, and it was when you're trying to judge purpose, that's not you did X, Y, and Z. Okay, you get it.
Yeah.
You didn't do X, Y, and Z. You don't get it.
Right.
This is a purpose.
100% subjective.
Absolutely, and that's a problem.
Which leads to favored people receiving results.
That's why
leads to corruption.
That's why I had
and
no
then you
question
have
that
these
it was-
two individuals who are the in this case, who were by both accounts, both sides said these are ordinary law-abiding citizens,
right,
with no criminal history, anything like that,
right.
And when they apply for it and they say, well, I want it for self-defense, or I want it because I've got tons and tons of experience with handguns and rifles and want to be able to possess these, they say, well, no, that's not good enough.
Yeah.
Let me ask you a question
First, Reid, I want to lay out for them exactly what the sort of issue was, what the law said, and what the issue before the Supreme Court was in this particular instance. Sure. So when we talk about may issue laws, may issue means that you check a bunch of boxes. In other words, I'm not a felon, all right? I'm not out on bail or bond. I haven't been committed to recently to a mental facility. I'm not a fugitive from justice. I'm not an illegal alien. You check all these boxes, and then you have to, in New York, in this particular case, had to show some specific need different than the general public for you to be able to carry it in public to protect yourself. You had to be able to, I carry money for a living. I'm a bodyguard for a celebrity. I, walk through this particular area of town and I've been mugged 5 times, something like that. And it was up to a government official to actually decide whether or not you had a sufficient enough purpose to actually issue a license to carry in public. And that's what the extension is here. Yeah. In this particular case, is allowing you to carry in public, and whether the government can actually write a law that says we have any discretion about whether or not to allow you to carry in public once you've checked these boxes. So that's like a May issue, and there's about 7 states that this is affected. But that have these type of laws, and like you said, it's a never issue type issue, but where these states have figured out a way to make it discretionary, and so have basically never given them out in these because they want to withhold people being able to walk around.
Let me ask you, Chase. This hits on your point. So you mentioned it when you were talking about checking the boxes. When people look at the Second Amendment or any amendment, but specifically this one, when it says "shall not infringe," that's what people always want to bring up. So this amendment has been infringed upon. How does that happen? Because how is it that it's not unconstitutional that a felon or a mentally ill person? How do you go about that to the people who are listening and watching? Explain how that process works, because I believe it was the Gun Control Act of 1968 that did that. Why isn't that unconstitutional? And was that done by the states or government or what?
Right. These things were done typically by the federal government. These acts that were passed were done by the Congress. And one of the things that the court looked to in this particular case was history and tradition. Okay. And history and tradition has to do, we talked about it before, when it comes to abortion, we're talking about what that word liberty means. What does it traditionally mean to have liberty in the United States? What is necessary in order for you to have freedom? And one of the things that they really hit upon is the Bill of Rights, the first 10 amendments to the Constitution. And the actual Second Amendment is one of those issues in the Bill of Rights. It has been part of our tradition, whether it's English law, whether it was colonial law, for us to outlaw certain people from actually being able to carry and possess certain types of weapons. This is something that has been in place since that time. It was very, very clear that you couldn't do that. There's a lot of laws that state you couldn't brandish weapons in public for the purpose of actually terrorizing and scaring people. Okay, those things were in place at that time. There were a few bans. You had bans when slavery came around. Everybody was terrified the slaves were going to revolt and kill people. So there were some things like that in the antebellum South where the federal government wanted to control the Southerners, and they were frightened that if they could, all have weapons again, that we might have this type. So there is some tradition of actually regulating those people that are most specifically likely to actually cause harm, and there's also a tradition of what they call sensitive places. And that was actually argued in this New York case. They said that New York and in Manhattan was a sensitive area because it was so densely populated.
Just because it's busy.
Yeah.
It's a sensitive area.
And
that was the argument. Like I said,
it's not before, a courtroom.
But,
it's not a...
Like I said before, there's always an argument to be made. I'm not saying it's a good one.
Not a government building, not a child's elementary school, but just... Manhattan.
Got a lot of people.
Right. And I think that all those things are going to still be in place as far as these traditions of having people not having access to military style weapons. Believe it or not, that came about. I don't know if y'all remember seeing like movies about the 1950s, and you see the gangsters with the Tommy guns and stuff like that. Well, the St. Was it the Valentine's Day Massacre?
Yes.
Okay, that brought about national outrage, and these mobsters gunning each other down, Bonnie and Clyde.
Right.
Okay, that was they're like, we can't contend with these types of weapons, and that's what kind of spurred some of this legislation to come about to try and control some of these more devastating type weapons. And everybody recognizes that these have limits.
Right.
And a lot of these decisions, that's what they do. They try to the Americans are very focused on personal autonomy.
Right.
And the rights are enshrined there in the Constitution. And then states try to make laws that infringe upon those or the federal government tries to. And what the Supreme Court says is, based on the Constitution, you have gone too far into that bubble of individual rights. And with this case, New York versus Bruen, what they have said by making it discretionary for a government bureaucrat just to say, I don't think you made a good enough case, and there's no hearing for you, okay, you violate the due process clause of the 14th Amendment. You have to have due process before you can take away someone's liberty, property, or life. And in this case, this is a liberty issue. And so because there's no hearing, that's why it violates it, number one, and there's so much discretion by the government, and the federal government basically, or the Supreme Court has said that you can't do that.
And I think to the folks at home, it's you need to keep in mind that this is not something that's ending this argument.
No.
This is a very, very specific thing that New York was doing that the court says you can't do.
Yeah.
But there's still going to be tons and tons of new cases with new gun rules, new gun laws, and those are going to be challenged, and we'll see where that ends up. I don't know.
Sure, and what you look at is,
But my point is, like, this didn't
really affect 43 states,
right?
Right, and it only affected 7.
Right.
So, the majority of states are already acting within the confines of the Constitution,
right?
So they're picking off outlier type places and trying to get congruency,
right,
or
with all the states,
getting things all equal,
right,
within all the states, and that's probably one of the reasons I think that they picked this particular case up and decided to act on it.
Yeah, because it was building up. There were cases, once one state passed it and had success with it, nobody challenged it.
Right.
Another state adopted it, and it became ripe at that time for certiorari because it was starting to build. They had, like you said, 7 states with that type of law, and with a gun lobbyist like the NRA, they can't afford to help fund these types of cases. And these are people that are American groups that are trying to put forth a direction for the country and what they believe is actually a good direction for the country, what their rights are. And like I said, we are as Americans very focused on the individual's rights. And when we talk about these mass shootings that occur, they are absolutely horrible, and I think we're all equally horrified by that. And a lot of countries don't have them, have these types of things. A lot of countries have guns. You have Switzerland, highest, gun rate per capita, right? Doesn't have all these types of shootings. So it's something within our culture that I think we need to really focus on and address. I'm not sure that even if you take away guns, it might be harder for them to do mass shootings, but there's something in our culture that's causing people to go and want to do these things.
Sure.
And so as much as, like, I'd be willing, and I think all of you in this room would be willing today to give up every right that you have to a gun ever if it meant that none of your nieces, nephews, kids, brothers, sisters ever died of any sort of died of gun violence. But you can't guarantee that.
Right. That's going to be the hard part for us as a society to figure out. We talk about our rights. We've given up rights all the time.
Yeah.
Driving a car is not a right, but it's a good example. You kind of you go to the lowest denominator. I feel like I can drive at almost any speed, to be honest with you. I really do. But I don't.
I've ridden with you, and you're an excellent driver.
I'm an excellent driver.
Oh, cold trickle over here.
I feel like I could do it. But I don't, because there's laws that say I can't. And so I think that and Chace, I agree with you. It is a cultural problem. There's no doubt in my mind that that's where it stems from.
Yeah.
But I think in the future, there's going to be some kind of action that regulates what type of gun, not necessarily. It's going to break down that all guns versus what type of gun. And then I think we're going to have another decision for the Supreme Court. We'll see.
Yeah, well, I think what's interesting about that, especially with this decision and the decision overturning Roe v. Wade, Dobbs v. Jackson, and Women's Health Organization, is what you're seeing is a court that's saying, look, we're going to look to history and tradition.
I agree with that.
And these words that are actually, we're going to look to what was in order to decide what it means. And if you want something different, then you vote the people in to make that happen. They're saying that these things are for the state to decide. Abortion, but in this particular case, the gun rights, there's a limit to where you can, but it's going to push state legislatures in one direction, and I'm gonna say I'm nervous, but I think it's going to have the effect because there's always a pendulum.
Always.
Right, where you have a decision like this, and it's going to spur voters on one side to go one way and spur voters to go by on the other. But before you get upset about the decisions, or before you get upset about the fact I said this is going to swing that stuff, what I want you to realize is that your conservatives out there, they are...
Why did you look at me, Chace?
Because you are a conservative, Shawn. Okay? Conservatives hold on to what's sacred. They hold on to what has worked in the past. They hold on to what our ancestors taught us. And the liberals always fight against. They want progress. They want
that's the
some things to change, right?
It means change. That word means something different from the status quo.
Right. And as society changes, that's important to do, to actually hold on to what works, hold on to what's sacred, and also try to move it forward incrementally. And so this struggle, if you're a conservative and you feel very passionate about the Second Amendment, great. And the abortion, great. Okay? If you're a liberal and you feel very passionate about both these issues as well, great. The struggle between the two is what brings us gradually and incrementally forward without losing what is sacred and what has worked in the past, while also progressing and becoming a better society.
I think incrementally is the best word that you could use to describe any of the Supreme Court type cases, because that's what we want. We don't want a knee-jerk reaction and laws made in a particular way or rights stripped away in a particular way. And when you see, the Heller and McDonald cases, they said that it is a fundamental right for you to be able to have, a firearm
in your home.
In your home.
Yeah.
And in this case says, well, if it's a fundamental right to have it, and it's a fundamental right to be able to defend yourself, it's a fundamental right to be able to have it and
walking around. Yeah.
And and that goes back to how do you decipher the Second Amendment? Because, and we talk about it, it's not very long, but there are arguments over the definition. Is keep separated from bear? And there's been fights over that. Sure. Can you keep it or bear it?
That's actually decided in this opinion. Sure. That's one of the things they actually mentioned. They mentioned that bear it means being in public.
Right.
Keep it means to have it in your house. And so that's one of the things they really hung on. So you picked up on that.
I'm saying it's
the first time it's ever been interpreted.
It's every word. Every word has to mean something. And Shawn, I'm sure that I'm more for gun control than you. I'm not for outlawing guns, but I thought that you're talking about the pendulum, that the New York law, the pendulum, that's way too far.
Absolutely.
It's way too far. There's got to be some middle ground, and what I'm afraid of, like you're saying, Chace, is the pendulum swings back and forth until it finally rests in the middle, and we just keep having these wild sides, and we just got to kind of get to a middle ground that we can accept.
Just like I said earlier, 43 states were unaffected by this.
Absolutely.
And then you have, some outliers that are, often we can designate who those outliers are going to be,
right?
Based on political background and who's in power in those places. And that's the people that are super progressive, having, laws enacted that push the limits.
When you talk about these pendulum swings, it's very easy to get angry at the other side because you think that their opinion is crazy and ludicrous or whatever. But everybody had the experience in their life where they go to somebody that has a different opinion from them and they say, hey, you might want to stay with this girl, or hey, you might really want to leave this girl. This girl's not good for you, right? And then looking back, you're like, man, that person was looking out for me. I know that was hard to come in and say, hey, you shouldn't be with your wife, or you shouldn't be with your girlfriend, whatever it is, right? I mean, I have opinions 10 years ago that I would vehemently fight with myself about today, right? But what you need to recognize is that person that's very, very different from you might help you to actually have a better, more well-rounded understanding of the issues that because you're dealing with complex issues. You're not dealing with black and white. Everybody thinks right and wrong is so clear and simple and all that stuff. No, it is in the gray area where the magic is the gray area where I think that we all eventually end up living. And so you should appreciate your people that are left-leaning. You should appreciate your people that are right-leaning, as long as they're reasonable.
Yeah. It's the pendulum. I mean, not the pendulum, the bell curve.
Yeah.
And you got crazies on both sides
Yeah,
of
yeah.
the curve, but most of us are in that bell curve.
yeah.
And you might disagree, but it's not to the extent that you see on
Yeah.
television to make riots and all that.
Anytime you have more information and more debate on a topic leads us all closer to a common ground that makes sense for everybody.
Yeah.
But I think it's interesting, Shawn. I lost my train of thought earlier. I want to ask you. So, a man who's been a police officer, an investigator, and been employed by the state. My dad obviously been employed by the state a bunch. I've told the story about
A lot
him.
longer than I was.
I told the story about him saying, if you get pulled over, tell him it's your dad's car. He's got to be here before you check it. So, this law to me, for the New York law, that is so wrong, in my opinion, is that you have somebody for the government to decide if you can have it. And it's not a court, it's not a hearing, you don't have a trial, you don't have any, you just have some guy, basically.
Or girl.
And I don't trust the government enough to have a person that is not bought off, paid off,
Don't
like me for a certain reason because of my hair color or because you're bald, whatever, then say you don't get the gun. Would you agree with that?
Absolutely. It's just, anytime you put that type of subjectivity into it and you are in a regime, because, in a government that is relatively left-leaning or anti-gun. Well, most of the legislatures in New York are, definitely in New York City, the mayor and everybody there is, the judges in that area, and a lot of those people who grant or deny those applications are judges, justice of the peace of things, are likely elected or appointed by the same people that are electing these other individuals.
And
you're going to have a common...
They get elected by funds that help get their name out. Yeah. And those people have other motives as well.
And quite possibly.
I am a little bit more left-leaning, but I am going to use this platform for a different reason, just a little bit, this tiny little platform I have. And I have a solution for this whole entire problem.
Oh, gosh. I know, Chase, your solution
Here
is
it comes.
horrible. I already know. You're going to look
It is not
I know what it
horrible.
is.
It is
Absolutely.
genius. Mandatory military service. Mandatory military service for everybody.
Don't you think that would infringe on your due process and liberty?
Look here, man. I'm not saying how we're going to accomplish it. Okay, I'm saying mandatory military service for everybody. For one, you're going to meet people that are culturally different than you.
Yeah.
You're going to be forced to rely on them. Okay, you are going to be trained,
cultural, sexual,
all that. Right,
everything.
Right, exactly. You are going to have a different connection because you're going to have.
Saying
Wait,
you're
no, you
wrong,
have to
Chase.
let me finish, Reid. Don't talk. Okay, I'm going to pitch this to my congressman. Look, Senator, all right? Mandatory military service, all right?
This is the worst argument I've ever heard.
No, it's fantastic. So you have somebody that's going to go, say, 2 years. They get actual firearms training, so they know and understand what they're actually doing with a gun. Okay, then accidental shootings. What's the effect of that going to
Chase,
be?
I think the pendulum is swung.
And then okay, you have Americans coming together. They're going to have a sense of duty. How many people have y'all interacted with that have been in the military, and you see a difference in the way that they dress, the way that they stand, the way that they behave? They are more regimented, more. All right, listen, and then I know you've heard this, but you gotta let me finish. All right, last thing, okay, is that you're going to have for 2 years a drill sergeant. Somebody in the military overseeing a person that is using this firearm. And do you think that they're going to have a good gauge as to whether or not that person should might be dangerous and go in and do a school shooting at 20 years old? I think they are.
The only place that I vehemently disagree with it is the action of the government taking place as the nanny. All these things I think are things that parents need to raise their children up with. If a person wants to get
It goes back
involved,
to cultural.
if a person wants to get involved in firearms and buy firearms, I think it's on that person to receive the proper training. Know what is safe and what's not safe to do. Things like that. I think we have plenty of people in the military. And there's plenty of people that are, not cut out for higher education, not cut out for a particular set of, trade. And those people end up in the military a lot of times and do great for it because they find what the good thing is for them, and they educate them and train them in that area. But I don't think the government, forcing us to be in the military, so that we can be better citizens is a good idea.
Chase, I'll tell you, I don't think that your idea is a bad idea. I just think it's, I'm not even going to say improbable. I'm going to say impossible. So I think we got to do baby steps, and that would be your solution, as it may work.
So,
with the pendulum would have swung.
Well, let me ask you this:
off the hinges.
Would it be more likely that Americans would agree to mandatory military service, or more likely they would agree to give up all their guns?
More likely mandatory military service.
Correct.
More likely.
Exactly. Would mandatory military service likely cut down on the number of accidental gun deaths?
Let me ask you this, Chase. Is it more likely that there's another action in between what you're saying and where we are?
Yeah. Yeah.
I think here's the thing. I think we can all agree that there's a problem in the United States with guns and the people who have them that are not using them appropriately.
Correct.
The question is, how do we get out of that? There's going to be more litigation. And one of the things I don't like that the Supreme Court has done is have this hasn't been decided in so long, like you were talking about earlier. That's another issue. That's another problem because you don't have, as you said, history. The law isn't as set as some things like a slip and fall case. How can a slip and fall case have more law than the Second Amendment?
Yeah.
And so to me, that has really let us down, and now we're in a situation where we don't have a lot of interpretation, and a ton of it is left open to interpretation because we don't have the history with it.
That's right.
And that's a problem.
Yeah.
And that's going to be fought out for years and years and years.
Yeah, and just so you know what Reid's talking about is that like this issue about these types of laws, okay, have been heard in there's I think 12 courts of appeals right below the Supreme Court in different districts, and they have all used different ways to invalidate or validate laws just like this. They've used what they call strict scrutiny, where anytime there's a fundamental right that's been violated, what they do is they see if there's a compelling government interest to actually regulate whatever law or issue that is, in this case, carrying openly in the state of New York, and whether or not that law is narrowly tailored to accomplish the goal of whatever it is, public safety. And then some of them apply what they call intermediate scrutiny. These are very normal terms if you're talking about constitutional law, and basically usually that involves a very a subject class, an identifiable subject class, and you have to the government has to have a substantial interest in actually regulating that conduct or whatever it is. And it has to, the means that the government uses has to be directed at actually controlling that particular type of behavior. Right. But in this situation, the court just said history and tradition is the way in which to interpret it. And they did that too, because we got to talk about it just for a second, okay? Sure. In the Dobbs v. Jackson case, where they overturned Roe v. Wade. And again, we talked about it last time in one of the podcasts we had before. You can go back and view that. We discussed it at length. And we talked about how the court interprets the 14th Amendment and what's included in liberty. And they went back again and looked at American history and tradition. Sure. And whether or not the right to an abortion was something that was within the American history and tradition. Right. So that's difficult because of the way in which people have viewed that issue, because and the people on the other side of that argument, I'll just frame it for you, is that they say it's a privacy right, that it's a right for an individual to make between them and their doctor about a medical decision about their body. Now, the government being involved in a decision about whether you can have a gun or whether you can make a medical decision, those are those are different. Those are different things, and they involve a lot. But one of the things that Justice Alito said in his opinion that I really agree with, and I don't know how I feel about the opinion yet, to be honest, okay, was he says this is such a contentious issue that the people in the states in which this law is going to be enacted, okay, should have a say in it, and it shouldn't come from us.
I think the two-party system has split us way too harshly.
Yeah.
And you know, and there's definitely some balance that is missing.
Yeah.
For our nation.
Yeah.
And I don't know why that is, but it certainly has been more divisive in my time on Earth now than it ever has been. And we have to come together, you know, and it's not win and lose.
No.
It's come together and figure out a way to, you know, right these wrongs.
We have to make it a win-win.
Yeah.
And like when you have contentious issues, you have real serious problems in your life. A lot of people turn to art, or they turn to religion, or whatever. For me, I turned to art, and George R. Martin? Mm-hmm. I said, "Chaos is a ladder."
Right.
Okay. This is chaos if I've
Sure.
ever seen it. You know,
Well,
with what's happening in the economy, what's
Right.
happening in the laws in the United States, or whatever. What's going to emerge out of this is a new, I think, national ethos, and a new national sort of like coming together, like where the reasonable people on both sides are going to say, we're rejecting
The crazies.
you crazy guys.
That's what I hope for.
That's
That's
what
the
I hope
only
for.
thing I hope
Right.
Me
And
too.
and I just think that we need somebody out there that
Maybe
has an
it's you,
idea like
Chace.
mandatory
Maybe
military
it's you.
service
Maybe
to
it's
come
you.
forward and
Step
and
up.
yeah, exactly.
And really,
Be careful.
right.
They'll start regulating you if you
No, come on.
even hint that you're going to run for any type of an office.
right.
Look,
That's right.
I have a bar license and I'm ready.
Okay.
I'm looking for a fight.
Yeah.
Please regulate me.
Exactly. But for the folks at home, like, you know, me and Shawn, we disagree on things. Me and Chace disagree on things. Chace and Shawn, y'all disagree on things. But we can talk about it, and I can learn from you. You can learn from Shawn, and vice versa. That's what we got to get to
Absolutely.
as a general public.
We still have no problem going and playing golf together
Absolutely.
on Saturday.
Exactly.
Yeah.
And
when
that's the problem I see in society is if you have a difference of opinion, it's like, well, you're a terrible person. No, it just means there's a different opinion.
Yeah.
Sure.
Yeah. I have many a time been very, very convinced of a thing and then stepped in a hole and had my leg clapped in a bear trap. And I'm like, oh, God, I wish this hadn't happened. Right? And so,
Prove me wrong. Yeah.
But when I get really certain about an issue,
Yeah.
I start looking around. I'm like, I stepped in a hole before. Who thinks differently than me?
Right.
And so I got a couple people on speed dial. Okay, it is Brad Salmons and Shawn Merzlak and Michael O'Connor. Okay, these are people that think differently than me, that are reasonable, intelligent, smart people, but their brain just works a little bit differently. And if it can help me, navigate life and understand life in a better way, so that I don't make mistakes and I think differently and I can be more moral, more just, then I need to rely on them. And I think that's one of the things that's really missing in American society today.
I agree.
Is the recognition of, I saw a little kid, it was terrifying. It was terrible. Little girl crying to her mom because she was like, Daddy called me a Democrat. She was crying. And it's like, that should not happen
Right.
in
Sure,
this country. Okay, because Democrats aren't evil, Republicans aren't evil. It's not. It's just you're disagreeing on an outlook on life, but you're both necessary parts of a whole that push this whole country forward. And it's when you villainize each other that there's a real problem.
Once heard at some type of a law conference, like one of those judges panels, that are up there, was a judge that was, I think he was a prior prosecutor and then did defense work, criminal defense work, and then did some civil work, and then he was a judge. And they had asked him a question about, what is the, most pitfall that attorneys should avoid. And he said, always arguing your case based on moral superiority. No, argue your case and discuss your case based on the facts and your feelings and everything, but don't take it to the level of, I'm morally superior to you, and this is why I'm right. Let's have a discussion. Let's talk about things. And
Right.
you change my mind, I might change your mind.
And it might be
Who
just
knows?
a little bit. It's just a hair. That's fine.
Yeah, because inherent in that stance is that the other person is the villain.
Right.
They are immoral.
They're the bad guy.
Right, right.
they're
right.
wrong
and
no
that's-
matter what.
Right, and that's not how you do it. I mean, anytime in the courtroom, people are looking for a leader, and a leader doesn't do that. A leader doesn't like demoralize or whatever. They show through, reason, through logic, that they are leading the people towards the right answer, towards the truth. Okay, in a conscientious way. So, guys, I've really enjoyed talking to you guys about this today.
Great time, as always.
Yeah,
Fun.
yeah. And
I'm gonna go outside and fight somebody. It's fine.
If you enjoyed today's podcast, please like and subscribe. Next week, we're going to be talking about ways in which you can actually have an interaction with police, assert your rights, and walk away from it happy and healthy, both you and the police officer. So thank you for watching, and join us next time on the Layman's Law School.